Hello viewers, welcome back to my channel Legal Decipher. In the previous video we had discussed about documentary evidence under chapter 5 of the Indian Evidence Act of 1872. If you have not seen that video, you can go and check it. The link is in the description below. In today's video we are going to move on with chapter 5 and talk about public documents and presumptions as to documents. So if you are new here, please like and subscribe to my channel to get the video notifications. So let's get started. So in this video we are going to discuss about public documents. Now what is a public document? Section 74 talks about public documents. It says public documents are those documents that forms acts, records of acts of any sovereign authority, official body and tribunal, public officers, legislative, judicial, executive of India, Commonwealth or any foreign country. So whenever any document forms acts or records of acts of any sovereign authority or any official body or tribunal or public officers, legislative wing, judicial wing, executive wing of India, the Commonwealth countries or any other foreign country, then that will be deemed to be a public document. Also, public documents are those records that are kept in any state of private documents. Those are also considered as public documents. So if we go through the section, we will clearly understand that any government document or any legislative document or any judicial document or any executive document or documents of the official bodies or tribunals, all these documents are public documents, and it includes the documents of the Indian government, the Commonwealth governments or any other foreign countries' governments. Also public records that are kept in any state of private document, that will also be deemed to be a public document. Now what is private document? Section 75 says all other documents are private documents. So whatever is mentioned in section 74 are public documents, and whatever is not mentioned in section 74, those documents will be deemed to be private documents. So by going through section 74 and 75, we can quickly sum up the distinction between the public document and the private document. That is, a public document is prepared by a public servant in discharge of his public duties, while a private document which is prepared by a person for his private interest under his private right. While public document is available for inspection to public in public office during appointed time after payment of fixed fees. So if a person pays a fixed amount of fees and he intends to inspect those documents during the official public office hours, then he will be able to do so. While private document is in the custody of the person to whom it belongs and it is not available for general inspection to the public. Now, the secondary copy of a public document is to be admitted in judicial proceedings, but without proving one of the conditions that are laid down in section 65 that we have already read about in the previous video. The secondary evidence of any original document is not to be admitted in any judicial proceedings. As a general rule, the public document is proved by secondary evidence, but as a general rule, the private document is to be proved by original, that is the primary evidence. Now the court is bound to presume the genuineness of a public document from the duly certified secondary copy, but no presumption is to be made about the genuineness of any original document from secondary evidence of any private document, except in some exceptional circumstances. So that is the basic distinction between public document and private document. Now section 76 entirely talks about the qualities of certified copies of public documents. So whenever there is a public document, a person after giving a prescribed fee can avail the certified copies of such public document, and such certified copies shall be provided to that person only after paying of such prescribed fees, and the person shall have the right to inspect those documents. Also the person shall obtain a copy if the conditions to obtain such a copy is fulfilled. Also the copy shall have certificate at the foot of that copy that it is a true copy. So there will be a small certificate at the foot of that copy designating that copy as a true copy. Also the copy shall be bearing signature, seal, date, name and official title, And explanation says that any officer who by the ordinary course of official duty is authorized to deliver such copies shall be deemed to have the custody of the documents within the meaning of this section. So whoever is authorized to deliver copies is deemed to have the custody of such document. Now section 77 talks about proof of documents by production of certified copies. So such certified copies may be produced in proof of the contents of the public documents or parts of the public documents of which they purport to be copies. So that will be the proof. The certified copies will be the proof of the contents of the public documents or their parts. Now section 78 talks about certain official documents and how they will be proved. So there are certain official documents that are mentioned in these 6 clauses, and there is a procedure to prove the contents of such official documents. So we will read about them. So whenever it is an act or order or notification of the central government in any of its departments, or if such act, order or notification is of the crown representative of any state government or any department of any state government, then such act, order or notification will be proved by the records of the departments certified by the heads of those departments respectively, or by any document that purports to be printed by order of any such government, or as the case may be of the crown representative. So if these documents or records are found, that will be sufficient proof of such acts, orders or notifications and their contents. Now if it is a proceeding of the legislature, then it will be proved by the journals of those bodies respectively, or by published acts or abstracts, or by copies purporting to be printed by order of the government concerned. So that is how the proceedings of the legislatures will be proved, by the acts, abstracts or copies that are purported or printed by the government. Now proclamations, orders or regulations issued by Her Majesty or by the Privy Council or by any department of Her Majesty's government, it will be proved by copies or extracts contained in the London Gazette or purporting to be printed by the Queen's printer. The acts of the executive or the proceedings of the legislature of a foreign country will be proved by journals published by their authority or commonly received in that country as such, or by a copy certified under the seal of country or sovereign, or by a recognition thereof in some central act. That is how it will be proved. Now the proceedings of a municipal body in a state will be proved by a copy of such proceedings certified by the legal keeper thereof, or by a printed book purporting to be published by the authority of such body. That is how it will be proved. And public documents of any other class in a foreign country will be proved by the original or by a copy certified by the legal keeper thereof, with a certificate under the seal of a notary public or of an Indian consul or diplomatic agent, that the copy is duly certified by the officer having the legal custody of the original, and upon proof of the character of the document according to the law of the foreign country. That is how it will be proved. Now the last part of chapter 5 talks about presumption of documents. What does it deal with? It deals with a set of documents and the presumption of their genuineness by a competent court of law. From section 79 to section 90, there are certain documents that are classified here, and it is mentioned in these sections as to what will be the presumption of the court regarding such document, whether such document will be presumed to be genuine or not by the competent court of law. So let's understand. Section 79 talks about the genuineness of a certified copy. It says the court shall presume to be genuine every document purporting to be a certificate, certified copy or other document. So whenever there is a certificate or a certified copy or other document which is by law declared to be admissible as evidence of any particular fact, or if it is duly certified by any officer of the government, then that will be presumed as a genuine document by the court, provided that such document is substantially in the form and purports to be executed in the manner directed by law in that behalf. And the court shall also presume that any officer by whom such document purports to be signed or certified, when he signed it in his official character, he claims in such paper. Section 80 talks about presumption as to documents produced as record of evidence. So whenever any document is produced before any court purporting to be a record or memorandum of the evidence or any part of that evidence given by a witness in a judicial proceeding or before any officer authorized by law to take such evidence, or to be a statement or confession by any prisoner or accused person taken in accordance with law, signed by any judge or magistrate, that we have already read under section 164 of the CRPC. So if any of these things are given before the court, say for example evidence of a witness in a judicial proceeding duly taken by the court, or any confession taken under 164 of the CRPC, so all these documents, if they are produced before a court, the court shall presume that the document is genuine, that any statement as to the circumstances under which it was taken purporting to be made by the person signing it are true, and that such evidence, statement or confession was duly taken, and it shall be presumed. So as we have known under section 4 of Indian Evidence Act, whenever it says that the court shall presume, and it will be mandatory upon the court to presume it. The court cannot presume otherwise. Section 81 says presumption as to gazettes, newspapers, private acts of parliaments and any other documents. So whenever any of these documents are submitted before the court, then the court will presume the genuineness of every such document that are mentioned here in this section. Section 81A talks about presumption as to gazettes in electronic forms. So the court shall presume the genuineness of every electronic record purporting to be the official gazette, or purporting to be electronic record directed by any law to be kept by any person, if such electronic record is kept substantially in the form required by law and is produced from proper custody. So if it is kept by a legal person who was by law supposed to keep it, that means he was supposed to keep the electronic record, and if it was produced from proper custody, then the court will presume the genuineness of every such electronic record that is purporting to be the official gazette. Section 82 talks about presumption as to document admissible in England without proof of seal or signature. So when any document is produced before any court purporting to be a document which is by law in force for the time being in England or Ireland, would be admissible in proof of any particular in any court of justice in England or Ireland without proof of the seal or stamp or signature authenticating it. So it does not need proof of the seal or stamp or signature authenticating it, or of the judicial or official character claimed by the person by whom it purports to be signed. The court shall presume that such seal, stamp or signature is genuine, and that the person signing it held at the time when he signed it in the judicial or official character which he claims, and all those documents shall be admissible for the same purpose for which it would be admissible in England or Ireland. Section 83 says presumption as to maps or plans made by authority of government. These things will also be thought to be genuine. So if there is any map or plan that is made by the authority of the government, then that will be thought to be accurate and it will be thought to be genuine. Section 84 talks about presumption as to collection of laws and reports of decisions. So the court shall presume the genuineness of every book purporting to be printed or published under the authority of the government of any country and to contain any of the laws of that country, and every such book purporting to contain reports to decision of the court of such country. So these documents will also be thought to be genuine. Now section 85 talks about presumption as to powers of attorneys. So the court shall presume that every document purporting to be a power of attorney and to have been executed before or authenticated by a notary public or a court or a judge or a magistrate or the Indian consul or vice consul or representative of the central government was so executed and authenticated. So if it was executed and authenticated before these people, then the court shall presume that such document is genuine. Section 85A talks about presumption as to electronic agreements. The court shall presume that every electronic record purporting to be an agreement containing the electronic signature of the parties was so concluded by affixing the electronic signature of the parties. So the court will presume that those documents will be genuine. Section 85B talks about presumption as to electronic records and electronic signatures. So in any proceedings involving a secure electronic record, the court shall presume that such electronic record is secure and it has not been altered since the specific point of time to which the secure status relates, unless contrary is proved. So the court will, on the first instance, think that such electronic record is genuine. In any proceedings involving secure electronic signature, the court shall presume that the secure electronic signature is affixed by the subscriber with the intention of signing or approving the electronic record, and except in the cases of a secure electronic record or a secure electronic signature, nothing in this section shall create any presumption relating to authenticity and integrity of the electronic record or any electronic signature. So that is cleared by section 85B. Section 85C talks about presumption as to electronic signature certificates. So the court shall presume, unless contrary is proved, that the information listed in an electronic signature certificate is correct. So the court will think that it is correct, except for information specified as subscriber information which has not been verified if the certificate was accepted by the subscriber. So the only exception is that the information specified as subscriber information which was not verified, that will be the only exception. The rest will be thought to be genuine. Section 86 says presumption as to certified copies of foreign judicial records. So the court may presume that any document purporting to be a certified copy of any judicial record of India or Her Majesty's Dominion is genuine and accurate. If it purports to be a certified copy and it was certified in the manner that it was required to be, or in the manner commonly used in that country for the certification of such copies or judicial records. And Section 87 says presumption as to books, maps and charts. So the court may presume that any book which refers to the information on matters of public or general interest, or any published map or chart, if there are statements in it that are relevant facts and they are produced for its inspection, and it was written and published by the person at the time and place by whom or which it was purported to be, then the court may presume the genuineness of any such book, map or chart. Section 88 talks about presumption as to telegraphic messages. The court may presume that a message forwarded from a telegraph office to the person to whom such message purports was addressed corresponds with a message delivered for transmission at the office from which the message purports to be sent, but the court shall not make any presumption as to the person by whom such message was delivered for transmission. So whatever is found from the telegraph office may be presumed to be genuine, but the court shall not make any presumption as to the person by whom such message was delivered or transmitted. Now section 88A talks about presumption as to electronic messages. The court may presume that an electronic message forwarded by the originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with the message as fed into his computer for transmission, but the court shall not make any presumption as to the person by whom such message was sent. So the same conditions apply on electronic messages that are applied on telegraphic messages. Now section 89 talks about presumption as to due execution etc. of documents not produced. So the court shall presume that every document called for and not produced after notice to produce it was attested, stamped and executed in the manner required by law. So that will be the presumption of the court. Section 90 says presumption as to documents 30 years old. Whenever a document is 30 years or more than that old, then if it is produced from any safe custody, then the court may presume that such document may be genuine. It shall be in the handwriting of any particular person. Now the conditions are that such old document shall have a legitimate origin and custody. So that is what this section says. Explanation says documents are said to be in the proper custody if they are in the place in which or under the care of the person with whom they would naturally be. But no custody is improper if it is proved to have had a legitimate origin, or if the circumstances of the particular case are such as to render such origin probable. This explanation also applies to section 81. The same thing will be thought for a document that is an electronic record under section 90A if it is 5 years old. So that's all in this video. If you like my videos, then don't forget to smash the like button and subscribe to my channel. Thank you so much for watching this video.